Here is a reading of a response to a motion brought by Todd Jones, who has been deeply involved in my affairs since 1999, basically enforcing my exclusion from political and academic life at the University of Minnesota, which was unlawfully carried out by the University of Minnesota and the federal government because of my political leadership and activism there. That exclusion from the university political system, for instance, the university to which I was many times elected, began in about 1982, then was forced to go to Extension Division and also was able to be effective in many organizations. Although the university administration, including Frank Wilderson, directly in the Minnesota Daily, said it was very important for the university to exclude me from the university senate. That's old history, but here again today the same state officials and government officials are intervening as I once again seek a leadership position in the United States Congress. Related to the harsh actions of the state and federal government in response to my running for Congress in 2010 and 2012, which has pushed me into bankruptcy and really put my family in financial peril, the kind of event you might find in some kind of third world dictatorship or perhaps some communist country. So I'm going to read from this so that you can be introduced to some of what has been going on behind the scenes and what will happen if a person tries to assert their rights to run for a federal office. Comes now plaintiff and debtor Steve Carlson, in response to the motion of defendant, Department of Education, ED, to compel discovery, and puts forth my own motion. This court, this is the bankruptcy court, allow me to take the questions certified below to the 8th Circuit U.S. Court of Appeals to be determined with related questions that are already on appeal or about to be on appeal there. And in the meantime, to stay the instant proceedings. The instant proceedings are twofold. One is to question whether the exception to discharge for student loans should be applied, and the other to determine whether or not those student loan obligations, which were originally intended to fund my higher education, which was abruptly terminated by the state and federal governments in stages, whether that constitutes hardship under the law for which those can be discharged, allowing me to draw on my Social Security without further interference from Todd Jones. Or in the alternative, I'm moving to have my adversary proceeding for the undue hardship discharge of my student loan dismissed without prejudice, and with the understanding that I will be allowed to refile it at a later time. These motions are founded on the grounds to comply with the requests of Ed at this time is premature, and that it would be onerous, impractical, and irrelevant to comply with these extensive discovery demands at this point, and that these demands currently interfere with my ongoing bankruptcy appeals and election disputes, and that to grant plaintiff's motion would also allow the issue of the proper handling of the bankruptcy claims I have asserted in this case to be heard and determined by the 8th Circuit Court of Appeals, and would allow me to make a direct appeal to the 8th Circuit as part of the consolidated cases I will bring before them by February 14th, 2013. And in fact, one case is already on appeal at the 8th Circuit. Now, in fact, the issue of the finality of the previous student loan litigation in 1999, as it applies to this case, is already on appeal, or will be on February 14th when I file notice of appeal. Since the district court singled this case out, this student loan case out, as an instance of a purported disrespect on my part of the finality of court decisions justifying a ban on any federal court filings in this district. For somehow, U.S. District Attorney B. Todd Jones, Mr. Jones, through his assistant, has picked the 30th day after the judgments I must appeal to the 8th Circuit Court from the District Court in 12 CV 531, 532, and 1267 to schedule his hearing February 14th, directly interfering with my formulation of the issues on appeal for the 8th Circuit. The status of the pending 8th Circuit appeal at this point is that I timely took appeal from the denial of any federal review of my emergency unemployment compensation benefits. That was in 2010 and was granted IFP. I am currently required to be securing a transcript for the case, and my appellant brief is due at the 8th Circuit March 14th. That is another serious requirement I have to meet right now, which could impact my estate in this case, and so it is another strong reason to allow me to prosecute my appeal without this kind of demand from the U.S. Attorney's Office on this student loan case at this time. Now, this is wrong, this scheduling this on February 14th, and it can hardly be coincidence, and shows that it is wrong that Mr. Jones be the person to prosecute this defense of the Education Department, because in truth he is defending his own wrongdoing and has a conflict of interest, seeking to limit and bar any issues regarding whether his own conduct imposes an undue hardship for my ability to pay any obligations I may have regarding these loans ostensibly granted to allow me to pursue higher education at the University of Minnesota beginning in about 1977 under a government guarantee program, and to bar discussion of whether in fact, in view of unresolved constitutional issues and ethical issues, the bankruptcy exception of discharging these apparent obligations can be legally enforceable. For wrongdoing, for political motivation is involved in this case, and thus this is a violation of the First Amendment and Fifth Amendment to the U.S. Constitution, as well as the 14th Amendment, since the wrongdoing of the state of Minnesota is involved here and has been covered up by Mr. Jones' own wrongful conduct, which is in fact of a criminal nature. Now, the questions for which certification is needed and asked on procedure. Whether Magistrate Keys, that's Jeffrey Keys, where he did not know if plaintiff's procedural and substantive rights would be lost if he stripped out all plaintiff's Article 3 claims. Those are claims which have to go to a district court and not a bankruptcy court, which he said were commingled with the instant case. Does plaintiff have a right to assert these Article 3 claims in the bankruptcy court? And if not, how is this court to exclude them procedurally? And what claims may be stripped out? What is commingling? 2. Finality of previous litigation. While the claim of rescission of student loan obligations has been litigated with finality, that was in the 1999 litigation before Paul Magnuson, what is the binding finality of this litigation on the claims of undue hardship in repaying the purported obligation and the propriety of even applying the student loan exception to discharge in Section 1328 of the Bankruptcy Code? Now, how are the issues presented in the instant adversary proceeding bound by the rescission decision in view of undetermined constitutional and bankruptcy issues that were not, those constitutional issues were not decided with any finality by the federal courts? 3. Should plaintiff be allowed discovery for the full range of in re long time frame of events that's an 8th Circuit precedent for determining the discharge under the undue hardship, which is to say Do we include the past, present, and future ability to pay going all the way back to the time that I was unconstitutionally deprived of my higher education and federal financial aid? And 5, should damages be precluded as a remedy in the instance discharge exception and undue hardship discharge litigation? Facts and argument. Plaintiff has read the submission of B. Todd Jones and realizes that while Mr. Jones and his office have been fully informed that I am right now, 1, just coming off a campaign for the U.S. House of Representatives, which has unfortunately involved violation of my First Amendment rights requiring election litigation, with time-sensitive litigation pending at both the Minnesota Supreme Court and the Federal District Court. And 2, I am involved in heavy bankruptcy proceedings and appeals to the 8th Circuit, and they still have, in the instant motion, improperly concealed and misrepresented my actions, and also the posture of my litigation burdens. This is material concealment, very much like Mr. Jones' wrongful concealment of the fact that a crime was committed beginning in 1982, and perhaps before, with respect to these obligations I now seek to discharge. Mr. Jones and the district court also know that I am legally required to file the instant lawsuit in order to discharge my student loan. And that's because of a U.S. Supreme Court decision last year that you can't get a discharge without filing an adversary proceeding. So this is one lawsuit which I'm required by law to file. And Mr. Jones knows, or should know, that the proceeding is in fact different from any previous proceeding. Proceeding I was involved in with B. Todd Jones in about 1999 was restricted to whether the law as amended and interpreted at that time allowed me to rescind the loan, and that there are a different set of issues here. Specifically, have those actions of the state and federal government in knowingly imposing the collection of a student loan with interest, where the evidence of record showed a financial crime against me that damaged my education, my earning potential, and engaged me in oppressive litigation full of bad faith and bad intent to injure both my educational and financial rights. Have they contributed to, and do there exist a set of circumstances that impose an undue hardship on me to pay these loans back with interest or at all? So these are the issues in this current litigation. Furthermore, Jones' actions have constituted willful and malicious obstruction of justice in order to perpetuate the original crime and thus act as an accessory. Apparently, the magistrate at the District Court, U.S. Magistrate Judge Jeffrey J. Keyes, and U.S. District Court Judge Joan Ann Erickson have each looked at this case, 12 CV 645, and have decided to make it a part of their very judgment. And so this case is in fact on appeal, but without any regard for my constitutionally and statutory secured rights in bankruptcy or my property and liberty rights in my higher education and my financial assets. The district court motion, which I will appeal, has sought to bar me from pro se practice now or in the future without a magistrate's approval, because they have said that my filing of this case, this very case, with what they baselessly charge is commingling of Article 3 claims shows quote-unquote disrespect for the final decisions this criminal action of Mr. Jones has procured. In point of fact, however, as this court and every bankruptcy judge must know, the issues in bankruptcy, while they do admit properly brought Article 3 issues, focus on core proceedings. One central point in the appeals from the district court's inappropriate response to filing these adversary proceedings, and this one in particular, is the failure to recognize that my rights under the Bankruptcy Code and the proper application of the exception to discharge for student loans established by Congress require an adversary proceeding in which I have a full and fair opportunity to assert all my claims and defenses. In other words, the filing of the instant adversary proceeding is no disrespect to the finality of the action of Judge Paul Magnuson in the 1999 case. In fact, if the court will examine that opinion and the treatment of the 8th Circuit of that case, you will find that clearly the constitutional claim of the deprivation of my higher educational and financial assets and rights were recognized by each federal court. While Mr. Jones was successful in insulating himself from findings of wrongdoing on multiple acts of concealment, And the record of that case, which is relevant here, will show that plaintiff debtor only discovered these concealed facts and the criminal nature of this government action during that proceeding. That this elaborate cover-up covered nearly 20 years of illegal actions by government officials. The University of Minnesota is a branch of the state government of Minnesota. Thus, the criminal actions of Mr. Jones actually helped to perpetuate that crime through the final decision by deliberately misrepresenting the salient facts to the determination of the rescission action itself. And Mr. Jones was able to cut a deal with the courts to pretend to ignore material evidence of interest charge indicating that the default occurred or was declared at a time when I was in school and fully entitled to continue federal financial aid. So there is an issue of what is the binding effect of the final decision in the previous litigation invoking the doctrine of collateral estoppel. All that Mr. Jones procured in the 1999 case was that the student financial aid statutes as they stood then, having been changed and the statute of limitations for certain student borrowers voided and abolished by a certain act of Congress, would not allow me to rescind the loan agreements. There was and could be no student default, since I was in school. This is the kind of issue that a bankruptcy court exercising bankruptcy jurisdiction, which this district court refused to do, necessitating the impending appeal to the federal appellate court. And this is the kind of issue that a bankruptcy court would examine to see to what extent the undue hardship claims I bring are somehow precluded for having already been finally determined in 1999. For the magistrate whose flawed findings the district court improperly adopted has not even determined bankruptcy claims I assert, and as such his recommendations are an inchoate set of findings which, without further clarification, this court could not separate out from the statutory undue hardship claims it is asked by Congress to determine, and to which I have a constitutional right by the bankruptcy clause.